welcome to the show. This is a No State Project Reloaded. This is a live show. I'm your host, Vin James. This is Darkcity Radio.
Into the lion's mouth, so you can see the nonsense of the administrative courts here. There's you only until you've seen it with your own eyes can you know what you're up against, and such as yourself and even Michael Doherty and Roger Hayes and all these guys that come back saying there's no justice. I can see exactly what they mean. It is an insane place, insane.
Absolutely, yeah.
One of the things that I did learn is that they've got their very own way of doing things, haven't they? So you've got you do have an opening statement, then the prosecution goes they send their witness up, and then you cross-examine, and then you can say, well, supposedly what's wrong with the witness or the evidence, and then the judge goes in the back. But of course, we don't want any of that. Our game is to try and stop it. So this is where we have to overcome all their assumptions, which is proving very tricky.
That's right. Yeah. Well, it's no two courts and no two police. Police services are up and down the country tend to operate the same way. They sometimes have different types of paperwork and the procedures. It seems as though even though these things get written down in books and these are meant to be the rules and procedures they're meant to follow, it seems to be that a lot of them take on or at least ignore that and say, well, actually no, this is the way we're going to do it. And they'll make up their own rules and regulations in that respect, and they'll get into a certain way of doing things, certain habits of dealing with these things, and they sod what the rules say, sod what the rule books say. It's as if they create their own policy, sort of thing. And I've noticed that a lot, especially when dealing with councils up and down the country. Two councils operate the same way regarding these procedures. So it seems to be the same way with the courts as well, like you noticed.
Is that roughly what you were expected to do? Because it's all kind of expected. Were you expected to give an opening statement? I know you would have probably kicked in with a few questions.
I never got to do that because of the way my one went. I mean, at the time when I did this for the first time myself in court, I was the only person that I knew in this country that had actually used this stuff. So I wasn't I couldn't compare it to anything, so I didn't know what to expect basically in that respect. So I mean, basically when I started off, I did much the same thing. I objected to at the start of the proceeding. They forced me into cross-examining the witness when I told them I wasn't ready, and I objected to that and stated, well, look, there's other issues to deal with here before I but even think of cross-examining the alleged witness. So it was. I just got in there with the usual questions. Am I entitled to a fair hearing? The conflicts of interest issue I never got to throw in there at the trial, but I certainly brought it up during the plea hearing. So I was just sort of at the time, I was still learning Mark stuff and getting familiar with that and basically putting it into practice. The more basic forms of questions. I never got too deeply involved with it. But I just stuck to the basics, and it did the job. I mean, it did the job in terms of still getting them to expose themselves to what they are. And even when I asked them, am I entitled to a fair hearing, I just got a hateful stare back from them. They wouldn't even answer that one.
Yeah, that's what I found.
In there, they had it in for me, and it was obvious,
Yeah, that's right. So. I mean, there's apparently. I mean, if you get a solicitor, which would cost you probably as much as the fine, they're so easy for the solicitors to get you out of, and they're just wondering why the hell you didn't do that. I think that's probably what they're what's going through their head,
because the money goes back in the same pockets of the same people who you want to get away from. You don't want to be bothered by, and that's the thing. So it's this thing of even if it's going to cost us more in that respect, not using them, we're not going to put it in your pockets.
Yeah, that's right. That's right.
And that's the way a lot of us view it. Yeah.
But there's pretty much no way you're going to you've got to be very, very smart to win on the way that the solicitors do, because you'd need to go a few dozen times to figure out their trick. And I think it's what they omit. So the witness will probably admit that he had received. It's something very obvious, but of course that's not the game that we're there for. We're there to question the whole applicability, and what I was finding the attitude was, because the statutes weren't mentioned. It was very difficult to get them to talk, so they just talk about, we posted it and he didn't respond, and the judge is part of it anyway. They're not impartial. No. So they do kind of ask you if not direct. They try not to ask you directly. Did you receive it? Did you post it? But they hint very strongly at the beginning that I should be telling them this now, because it would save me some money by the end of it. So there's I think what I'm trying to say is you've got to start right at the beginning and question the whole thing, because they're not expecting it. They don't understand where you're coming from.
Exactly. Yeah. I mean, you've got the right to put to the test and challenge every part of it, every part of the investigation, the claim, and every part of this alleged cult as jurisdiction. You can challenge that at any point as well. Same as what Mark says out in America. What you can do in the American culture, you can challenge jurisdiction at any point. Yeah. Even at the stage when they bring the charge against it, challenge jurisdiction of the police. The police can't claim jurisdiction unless they've got facts proving the law's applicable against you to begin with. Before it even gets heard in a court or referred to a court, they have to still prove jurisdiction. So it can be challenged at any point.
And of course, I think there's a slight. The process is exactly the same as the US and Canada. But there's some things, I always think there's something different about this. But I think what it is that it's that when they say they've got jurisdiction, they think it's their God-given jurisdiction. So when the American courts, they deal with a lot of, you call it, proper crime, where there's harm, injury, or loss, and they can deal with it in the traditional common law way without even thinking about it. They don't need to go through the Assault Act or the Being Drunk Act or anything like the Criminal Damage Act, because the American courts are cut out for just using sort of common law, but the magistrates don't know that, you see. So that's what I found. They were looking at me blankly. They don't know anything about common law. And common law has got a lot of different meanings as well, but it's just the structure of it to redress a legal injury, and they don't know that. They don't know. All they know is paperwork.
That's true. Yeah, I mean they don't. They think that the accusation is evidence in itself, as we've had with Helen and yourself. I think in your case that they pretty much said the same thing, didn't they? They regard the accusation, the paperwork, and the picture as evidence, as evidence itself to prove that an alleged crime had been committed.
Yeah,
they seem to think that's good enough, and it's not. It's as the case law I've been looking through this week, and I'll start posting this up for more people. We'll have this up on the website and on the wiki group shortly. It's accusatorial, which is adversarial. Still means adversarial, but they use the term accusatorial a lot, and it states that a charge is an accusation, and an accusation is a charge. They're vice versa. That's what it means. It's nothing more than that accusation. It is not evidence in itself. If you go onto the Canadian Supreme Court website, it states it at the very top. We do not regard a charge as evidence of a crime, and it is not. And a crime is not. And a charge is an accusation.
So you think says that? So we think we should be challenging not only the CPS, because they're going to be quiet for a while. I found they said as least as possible. This is going to be we really challenging the court, and we're going to ask. I think we should be asking them how they got this jurisdiction. You know, have you got?
Well, I mean,
this...
you're challenging the entire thing from start, or from the very beginning. You're challenging the entire investigation, the entire claim that's being made, and or the accusation. You know, and they just look at it. They look at you like you're mad for daring to challenge them. You know, because as we talked about before, you know, and during the role plays we did, their attitude towards you is you disobeyed us.
Mm-hmm.
That's it. You disobeyed us. Got nothing to do, you know, right and wrong, or you know, whether you broke the law or anything like that. You disobeyed us. You didn't do as you was told. And I think you said it yourself. It feels like you're a school kid again, being pulled into the headmaster's office, being told off. That's how it feels, and that's exactly how they treat you.
But just to get this thing going, I think we should be asking them because Helen's. Are you still here, Helen?
Yeah, you with us, Helen?
I am. Yeah, I was muted, but I'm here.
You said that when you asked about jurisdiction, they pointed at the coat of arms behind them and said, "Look, we've got jurisdiction."
No, it was when I asked her who she represented. She turned around and pointed at it and said, "I represent the Crown."
Yeah, that's it. And I think she thinks that gives her the power to enter pleas.
It only does if she's established jurisdiction.
Yeah, but in her mind, I think that because she was standing like that, she can do that. Same as a policeman think that they can. I think that it's kind of slightly different mindset over here.
Well, they think they can do it if you refuse to enter a plea. And Helen was very clear and concise, saying that she didn't refuse to enter a plea, but she wasn't able to enter a plea because she wasn't in possession of all the facts relevant to a charge being established. And the other interesting thing when pointing up to that crest was you pointed out that there's some Latin on that crest the other day, which says, roughly translated,
"It is my right." Yeah.
Is that what the crest says?
Yeah, it's I've seen different translations, but it means "it is my right," and I think some old kings who were supposed to have said it. You know, it says "right" in French, doesn't it? DROIT, right, and I think "it is my right" means it's one of the kings said it's my divine right, and that's what it implies, that it's a divine right. And I do believe that these judges think that they've been given it, not by the US Constitution.
Do you have any facts to support your opinion that you have this divine right?
Well, yeah, I think you need to bring that out. You know, just say, I'm just curious. How did you manage to enter a plea? I'm just curious, and they will probably tell you, and then you could probably work something from there.
They probably tell me. I asked last time how. She just said, we have that power.
We just do, we just do. And that's not a good enough answer, is it?
Yeah, I mean, this is the thing we're trying to show people, is none of this is a magic bullet in a sense of we're going to get this thrown out, because the X factor in all this is the people we're going up against. It's their state of mind, it's their it's their illogical and balmy ways of looking at the world. And this self grandiosity they have about themselves, and it's about all we're going to do during the process is we're going to expose the facts and show that they're ignoring every rule and regulation they're meant to be sticking to. You know, and we know they're going to behave that way. They're predictable, so we're going to let them walk into it. We're just giving them enough rope to hang themselves, because we know that they're going to act corrupt. They're not going to follow the rules. They're going to ignore anything we put towards them regarding facts or evidence or anything like that. They're going to convict you without any evidence ever being brought forward. It's all going to be based on an accusation, nothing else, nothing more, nothing less. And it's about getting it to appeal. And then once you've got it to that appeal stage, now it'll be on the record, now it'll be recorded. You can get transcripts, providing they don't fiddle with them too much. But you can get transcripts and you can actually start to expose this better. You can put them in a more awkward situation where now suddenly, oh God, now we've got to make this look good. Whereas at the point when they're in magistrates' courts now, they've been getting away with this for so long, they couldn't care less about putting a pretense up anymore about making this look good. The attitude is, you didn't do as you was told, we're here to punish you, end the story. We're not here to prove anything. We're not here to prove jurisdiction. We're not here to establish that an actual crime was committed. You know, it's all about you didn't do as you was told. You didn't pay the fine. You didn't bend over, and now you're daring to take us on. Well, we're going to teach you a lesson, and that's their attitude. And I don't make any. They don't go to any great lengths anymore to hide that fact that they're actually behaving that way.
No, that's right.
They seem to think that we're stupid and we don't notice this. Now they treat us like we're stupid and they're not.
That's right. Yeah.
You know, and we've all come across. I mean, you know, Helen's you know, experienced this now for herself, and she hadn't before. You know, before hearing the other week. Fabrice, I know, has gone through this. Now yourself, I've gone through it more than once now. You know, and I've sat with people on other cases, and they treat them exactly the same way. And this is the point about, you know, this is the point we have to get across to people. Expect them to act this way.
You can see it come through time and time again as they behave the same way, and sometimes they can be very, very eloquent in what they're saying, especially when they're informing you about costs, for example. They can sound very eloquent, but if you actually look at factually what they're saying, they're threatening you, and they're making no bones about it. And I think it's something that Paul may well come up in his hearing, is we've done this 1,000 times, as if that gives them some kind of free pass to not have to inform you of exactly what they're doing.
To not have to prove a case, you know, they seem to think it's clear cut. And the attitude is, well, if that's the case, then and this is such a clear-cut case, why do you need to bring me here? If this accusation is good enough, and that picture is good enough, my confession that I was driving a car is good enough, why did I need to be dragged into court? You obviously had nothing to prove.
Another thing is, I noticed that I was noticing that you know, their mindset. Just an observation is that, you know, not only do they think jurisdiction is given to them by, you know, their oath is just given, is that it is administrative. So this could have been council tax. It could have been just about any other stuff that people get ripped off on. It's not really about driving, and so they've got. I'm sure that their training manual says for this prosecution, the police need to provide A, B, C, D, and it's all labelled 1 to 6. And then the fella just says, and in the witness who I was saying earlier, who's got no personal first-hand knowledge, all he's saying is the administration was incomplete, and that's why you're there. So it is administrative. So you've also got to just distance yourself from, you know, the whatever day it happened, because they're just talking about what papers they've got on the table. So don't get too connected to when you were driving. So, you know, you take the position of what's all this paperwork got to do with me. I think that would be a better mindset to go with as well.
I think the interesting thing you brought up there, Paul, is that with the cuts in legal aid coming through soon as well, there's going to be more and more people representing themselves because they can't afford lawyers. And I think they're very, very used to dealing with lawyers, and they won't challenge jurisdiction because their license to practice law is dependent on them not questioning that authority. Being members of the Bar Association, if they would like to remain members of the Bar Association, it's not pertinent for them to question jurisdiction, even if they're instructed by a client to do so, because all their supposed authority to practice law is actually approved by the same mechanism that they would, you know, be questioning if their client requested them to. So the system in and of itself isn't used to laymen coming up and having the same rights as a lawyer, because they're representing themselves and saying, actually, I want to question this evidence. Okay? Even though no other lawyer questions that evidence because their license kind of precludes them from doing so, if you're representing yourself, you can ask those questions because they are very relevant to, you know, elements of the charge. And this is something that the legal system isn't used to. And as you can sometimes see if you have calls with the CPS, or sometimes when you have discourse with course officials, that you can see that they will try and take away those rights for you. Sometimes, as I think Vin's mentioned before, they will attempt to put somebody in the dock, even though they're representing themselves. If they have the same court papers as the prosecution does, they're not even going to have space to lay them out. Okay? And it's not because they're an inherent violent danger and threat to people in the courtroom, which is supposed to be the reason why people are put in the dock.
Yeah, I think that's disgraceful. I saw a lady in chains, and she'd been shoplifting in Tesco. It's just disgraceful.
It's all psychological. It's to make you look guilty and appear guilty before they've even heard or seen a word. So it makes it easier for them to fleece you.
That's it. Yeah, it's all intimidation once you're in there. They just want to intimidate you and have you cowing and submitting to them and not, and not standing up and challenging them. And I mean, when I went to court the other week with my friend to help him out, he was extremely confident in what he was doing, even though he'd only had a couple of hours practice me showing him this stuff, where to start off and how to start questioning. He was extremely confident. Yeah. And that threw him. That completely threw him. And like I was saying the other week, when before me and him actually even got to leave the room, the magistrates and the court clerks and everything went running out the back.
Yeah, it's good. I hope to see people all over the country, even if they make a bit of a shambles of it. At least I'll get a few questions in and say, what do you consider to be jurisdiction, and get them to answer. Well, it's just from the type of crime that we do, and just say, well, that's not good enough for me. You haven't got any facts.
See, this is where they can come at you and start saying, well, look, you're not a lawyer, you can't understand this, or it's blatantly obvious, you don't understand how the legal system works and all that. Agree with them. Say, yeah, you're absolutely right. I'm not a lawyer, I don't understand none of this legal stuff. However, I'm not completely stupid. I do understand objective evidence. I do understand objective facts. I can understand. I'm perfectly capable of understanding this from a layman's point of view. So, apart from all the law and the rules and regulations that you want to throw at me, all the legal stuff, what objective facts and evidence do you have that you can show me right now to prove that you have a valid claim against me?
But this is just to the judge. I mean, it wouldn't be that the judge has a valid claim. That say that you can even, hear this, because I'm not here by choice. I presume that they've got a case, but how do we know that? And but the idea is to get you all the way through to realise they haven't got any evidence.
Well, that's right. You've got to get it. I say to them, if they come out with all that stuff about, you're not a lawyer and you're not understanding what's going on, Torrent, say, yep, okay, you're fine. I'll tell you what. So, without referring to the statute that you keep accusing me of, without referring to that, do you have any facts that you can bring forth right now to prove that that's applicable to me? Without referring to that act, do you have any? Yes or no? Do you have any facts to prove that it's applicable? Then I can understand it. You start going off into tangents about legal this and legal that. Well, again, I'm not going to understand what's going on. You've got to lay it out to me, plain English, plain facts. That's all I want. I don't want legal opinions. Stop giving me legal opinions. Give me some objective facts, and challenge them on it. If they keep coming out with opinions against, call them out on it and state, well, look. When you talk about facts, what do you mean by a fact? And I'll tell you what I call a fact. I define as a fact. Tell me what you define as a fact. Are you telling me that you can simply take a legal opinion and call it, or do you assume that a legal opinion is as good as a fact?
We can. Most people now, I mean, probably more than years ago, can watch the TV now and just laugh at the political. You only got to watch the House of Commons, and it's a joke. But you when you realise it's going on in the court, you don't expect it to go on in the courtroom, but it does. It's all rubbish. They're talking absolute rubbish, and you should be able to call them on it.
Yeah, like I was telling you before, what shocked me was just how amateurish these people really are.
And they're not very good at hiding it. Yeah.
And yet they'll turn around against you and say, no, you're the one who's stupid. You're the one that doesn't understand what's going on.
That's right, yeah, that's right. And it's like... Right. As long as you make sure it's a question, and I don't understand, pretty much, don't give them an easy time.
Yeah, that's it. So Helen, you looking forward to it Monday? Silly question.
Well, you know, it'll be entertaining, I'm sure.
Yeah. Well, yeah. You know, you should look forward to it. Obviously, the attitude we should have towards this is we just want to get these buggers off their back.
Yeah, I'd rather they just let
It's a
them
learning
know.
experience. Yeah.
I think we're almost about as ready as we can be for it. So I would much rather they left me alone, but we'll do the best job we can.
That's it. Yeah. And this is what we say to people. You know, expect to get convicted. They're so corrupt. You've heard it from not just me now. You know, there's plenty of people in it, especially if you listen to Mark's site.
They might expect to get hit. I'm well aware they might just convict me. But I don't think they'll do either tomorrow, to be honest with you. I think they'll reschedule.
Yeah. To see what happens. I mean, say the thing is expect that. Prepare for the worst in terms of they're going to convict you.
Yeah.
But be prepared to go. Be prepared to go to appeal. And just the way what you want to do with this is use this as an opportunity to get enough leverage against them for appeal.
Yeah.
To trying to get the case kicked out. And if you're lucky,
process rather than the final thing, isn't it? And that's what we've got to remember. When they slap a charge on you and a big fine and points on your license, it's just not to be afraid of any of that. Just know you're coming back with the appeal.
That's it.
And none of it means really.
So you're just setting them up. Let them make all the stupid statements and come out of all the stupid comments and logical nonsense they like, because you know they're going to do it. So a lot of this is then giving them enough rope to let them hang themselves, and then that's it.
It's not trying to prove to them that they're not stupid, that they are stupid. It's just allowing them their stupidity, isn't it? It's just allowing them to say it and make sure you're taking notes on what they're saying. Allow them to say it, and then you've just got it there to come back on.
Yeah, I mean, it was in my case with the Crown Court appeal. The judge said to me, "Yes, it's a fact that I'm independent of the Crown and the police." And I went, "I didn't expect that." So I went, "Oh right, so you're claiming it's based on facts?" She went, "Yeah." So, "Oh great, okay. So can you show me those facts?" "No." She went. So I say they'll make statements. They'll just walk straight into it. And then as soon as you call them on it, bang, they're stuck. No, I'm not giving you those facts. It's so easy for them to walk into that because they're so used to getting away with this. They've been getting away with this for donkey's years, saying what they like and doing what they like, and then suddenly, they're being having their feet held to the fire this way, and they're not used to it. They don't know how to react to it. They can't stop to think. And that's a sign of when you're up against someone who's actually intelligent, when they're actually listening to you.
And another way of
they answer,
Sorry, but another way of looking at it is, in retrospect, it was. Now it's supposed to be, an independent adjudicator. Obviously, it's not. You've been accused of this. It's accusatorial, I guess is the word. But you've got to keep reminding them that they're supposed to be independent and trying to resolve it. So maybe that's another comeback as well. You are trying to resolve this. So could you answer my question? I think you should probably get them to say that as well. Mm-hmm. As a setup question.
Yeah, it is very good to remind them that you are there and that you just want to get it resolved, and that. What you're asking for essentially is evidence of jurisdiction. It's a necessary prerequisite for any court to hear any charge. That court must have jurisdiction.
Yeah, and if they come back with a daft answer, just say, "What's your interpretation of jurisdiction?" Because it might be different to mine. Because the basic thing is you're asking for the evidence right from the off. You're there in good faith. As soon as you receive the charge, if possible, you write off to whoever the prosecution is, and you ask them for the evidence that the whatever law, whatever code that applies to you, and evidence of a complaining party. And as soon as they give that to you, that's no problem. Or if they come back to you and say, "You know what, we don't have it," then you can throw the charge out. And that's all you're wanting to do right from the off. So the fact that they get you to go back to hearing after hearing, and they're not giving you that information, really does show that they're not bona fide, that they're not acting in good faith.
Absolutely, yeah, that's right.
Yeah, but so that I found myself on a completely different page to them, and I think we're learning how real courts work. If you and Ivan had a business and there was a dispute over a delivery or a service, we could take it to one of these courts, and we know that they would act reasonably well. If I hadn't actually lost any money and I just wanted to teach you a lesson, they wouldn't accept the case because there's no injury. I would just say, I want to teach him a lesson.
Absolutely, yes.
So that's another way of thinking about it. You're asking why I'm here, and what do they call jurisdiction? Because just tell them, you think maybe you're on a different page here. This is not how you thought the courts work. So can you explain how you're thinking here?
Yeah, in that sense, but I mean, you just want to keep to the facts. You don't want to keep hearing their opinions on how they think they have jurisdiction or what they think jurisdiction is. You just want to keep the burden on them. Show me the facts. Let them waffle on. Let them say, we've got this because of this, that, and the other.
And have you got any facts to prove what you just said?
How is that facts? What are the facts still? That doesn't tell me anything.
Yeah.
Exactly.
Yeah, I understand that's your opinion, but I haven't seen any facts.
Exactly, yeah, and I understand it's a fact that's the opinion. I understand that is a fact. However, that isn't the fact I'm looking for. It's the facts behind that opinion. That's what I'm interested in. So we've established it's a fact that's the opinion the law applies to me, or that's the opinion that you have jurisdiction, or that's the opinion that this copper caught me speeding allegedly, or that I'm being accused of speeding. I understand that as a fact, but again, I understand that as nothing more than a legal opinion. And I want the facts behind that opinion, and that's what you have to keep drumming home. To let them understand that you know the difference between a fact and an opinion, and you do have to keep that clearly in your mind as best you can. So a fact is something that's measurable.
Yeah,
it's something you can establish its invocation to its ultimate end if there's one. In that sense, it's something that's measurable. It's something you can get your head around. You can take it back to its ultimate source, and and get to the truth of what created it, where did it come from, how whys, wheres, and whens. You can do that with a fact. You can't do that with an opinion because it's subjective. It can come from anywhere. And so it's worse still when that opinion is resting on another opinion. There's a term we use now. It's called turtles all the way down. That's opinions all the way down.
Yeah. There's another thing that I learned, and this is completely irrelevant, but you've been accused by a witness statement, and it was pretty much what that whole. There's a series of statements about the process that this guy that you've never met went through, and essentially it's equivalent to a statutory declaration. I must admit, Vin, I had a peek in the procedures, and I know it's you shouldn't be doing that, but that's all it is. It's a declaration of facts, and they're all irrelevant. I posted a letter, so pick it up and say this is a statutory declaration. So this isn't evidence of jurisdiction; it's just an opinion.
Yeah,
just say there's no facts here.
It's accusatory at this point. It's just it's fair enough. I'm not disputing the fact that you claim you posted or did some paper, shuffled some paperwork around in an office, or posted a letter on a particular day. I'm not disputing that fact.
That's right.
But now you've got to take it from. Now you've got to go from that to prove that makes me guilty of something. That makes me guilty of a crime.
They fit that into the statutes.
That's it. And they seem to think that's good enough to accuse you of a crime.
Yeah.
And you didn't respond back to something. Well, yeah, fair enough. I never responded back to it, but I'm not disputing that. But now you've got to go from that to prove that proves that there's a crime. Where's the injury at damn them? If people look up on Westlaw the other day looking some stuff up. Had a terrible time using that database, Westlaw. Christ, that was worse than the one I was using before. But anyway, I was looking up Bailey. If you look up the Bailey website, Bailey website. It's the British and Irish, UK and whatever case law database. And if you put in certain phrases, such as corpus delicti and things like that, nothing could come up. You won't find a case. But just put the word in delicti, and suddenly bang, they'll all start coming up. Or put in the word accusatorial or adversarial, bang, it'll all start coming up. If you're using certain phrases that you're looking for, it becomes a little bit more difficult to find stuff. A lot of the time, nothing will come up. But if you use a single word, you'll start to see these cases, and they start admitting to this. If you put in delecti, suddenly you'll start coming up with or damn them, injury at damn them. Put in the word damn them, and suddenly you'll start to see criminal and civil cases flying out the walls, claiming that there has to be injury and damn them present for there to be a valid case. It's in there. We've got it in our case law just the same as it's in the American case law, as Mark's shown as well. We do have it there. So it's it's relatively easy to find. So if people don't believe us on any of this and think that me or Mark are talking a load of crap, then go and look this stuff up for yourself. It's there. It's in the case law. Yeah, it doesn't matter if it's referring to a case where it's criminal and there's a real victim, someone with a real injury, or it's referring to something abstract, such as the public and all that. It's all in there. You can find this stuff. It's it's not we're not talking rubbish, and this is the thing. So it's when you're challenging this, and obviously once you've got this in your mind and you understand what you're talking about, you know what you're saying is right, and you know what their opinions are on this stuff, you've got that confidence to confront them in court. So when they start talking this way towards you and they're acting this bloody stupid, it's not going to faze you because you're right. You know? And it's not going to knock your confidence, and you're not going to feel stupid. They're going to treat you as if you're stupid, but see, and that's the difference. That's what the confidence, learning this stuff and learning it this particular way, how it helps. Now it helps it rid you of a lot of that fear as well, and that's the thing we're going up in front of these people. It's ridding yourself of that fear. So I went off point there. I can't remember what we was on before, but
No, it's true. It's it is a stupid procedure, and it's administrative. And I say that they probably don't realise that, Vin. That's what I found. They didn't know where I was coming from.
Exactly.
So the questions are going to be the.
Don't let that put you off. Don't let that faze you. Expect them to act that way. Expect them to act like rank amateurs as they do. There's every case I've pretty much been in so far, maybe apart from one where they were acting a little bit more professional, and that case got adjourned and I wasn't able to, follow it up the way I would have liked. But, they generally act this way all the time. And they're not used to people holding them. It's like that video that came on, the Match at Home video. I'd encourage people to watch this. What was it again? The Match at Home video? It was a video on training lawyers, wasn't it, from America?
Yeah.
MC Ahone, Hahaon, I think, and it's a video this bloke done. He's meant to be an attorney, U.S. attorney, and it's a video that was made for training lawyers or training student lawyers, and he basically stated that you don't want clever people acting as juries in court. That's not going to do you any good. And you don't want intelligent and clever people on your juries. You want stupid, not necessarily poor people, because as he stated, poor and black communities generally don't convict people on crimes because they're on their side and not the state's. So what you want are usually middle class people who bend over backwards, pay their taxes, and never question none of it. They're the sort of people you want on a jury. You don't want people who are going to be clever and hold them to a high standard and pick that case apart. And it's the same with when you're acting as a defendant. They're not used to people coming in there and holding them to the standards that they claim they're meant to hold themselves at. Yeah. And that's what you're doing. You're simply just holding them up, holding that yardstick up that they claim they have to stick to. And you're saying, well, come on in. If this is meant to be the standard you people are meant to operate to, let's see you do it. Let's see you operate to an objective standard of truth. They can't do it. They've never been, and they've never been held to that level before. And this is the thing. It's not about you being smarter. You have to be clever to take these people on. You just have to be smarter about how you do it. That's all. You just have to use a bit of common sense, and most of us have got that. It doesn't mean you have to be clever to take these people on. Just a small bit of common sense is enough to expose these people and show them for what they are. It's as simple as just showing somebody that law's just nothing more than an opinion. And I've talked to people before in the street and held them to this and said, well, what do you think law is? Well, law is, it's what the court says and all that. Well, hang on, think about it. Isn't it just an opinion of somebody else? And they're like, oh, yeah, you're right, blimey. Never thought of it like that before, but it's that simple. And it does take a genius to come to terms with that and to understand it. But obviously when you're dealing with the courts and these people, they're so heavily indoctrinated in this stuff, that they don't switch out of that mindset. You're going to have a very hard time, shocking them and waking them up to that. It may occasionally happen. Like I say, we've got plenty of years ahead of us in terms of, putting this stuff to the test in courts and starting to get these cases thrown out a bit more regular. But this is the thing. We've got to expect this behaviour out of them and let them run with it. If they're going to behave that way, fine, get on with it. It's a car wreck and you're watching it. You're not involved though this time. In that respect, that they are. They're the ones crashing the car. So let them do it. Watch and let them do it. They're too stupid to wake up and realise, what you're saying to them.
I think that's a really important point, Vin, is to make sure that when people go in there and defend themselves, that they're behaving as well as they possibly can. It's also very important to make sure that you have as many people there as you can to see what's happening, and preferably look like they're taking notes as well, because that way it makes them more aware that they're putting on a show, and a lot of what they're doing anyway is putting on a show, and they're used to doing it quite regularly. So when you have people asking seemingly quite innocent questions about can they obtain a fair hearing, can they expect responsive answers so that they can be informed about what's going on, when they start to not help you along with that, when they seem to be not playing fair with you, the more people that you have seeing that, the more it exposes it. The more people that see that, believe you me, the less the fear works, as Paul was saying earlier. Once you get in there, and once you start seeing them behaving to type, when you're asking if they're being fair with you and they have evidence and it's all above board, they should generally help you along, to help you be informed, to make sure that everything's fair and above board. And when they don't behave that way and other people are there, then it starts to put the pressure back on them to hopefully get it out of their court as quickly as possible, i.e. dismiss it.
Yeah, I mean, something with me that I've noticed, what gets them spooked a little bit is if you bring the Human Rights Act into this. So, but because we can't claim rights under the Human Rights Act, because you can't 1 minute claim, well, where the facts prove this applies to me, and then the next minute go claiming, well, you've got rights under this act. The only question that I generally throw at them is to state, is this claim factually consistent with the Human Rights Act? They'll usually say yes, and leave that alone then. I usually never come back to that unless I can use it against them in some other form later. But just answering that question, sometimes that does get them spooked a little bit, because then they'll start thinking to themselves, oh God, this is going to become an issue under the HRA.
Yeah, I found that sometimes when you ask what are the rules of the court, they will specifically make mention of the European Convention on Human Rights. Particularly, I think Section 5, which is the right to a fair trial. Often because that's one of the questions that you've asked before then, and they seem to be very, very happy to spout their PR with that. When you start asking some of the more innocent questions, even though they're yes or no questions, they often like the sound of their own voice to bring it across, to make a big grandiose statement that yes, they are being very fair, and that the courts have been being fair for thousands of years, and this is the best system we have. And I don't think they were to inform you of it.
I don't think they were referring to administrative courts. They're dressed up to look like how we imagine these court scenes on TV from films, but it might as well be 3 or 4 people sitting in the pub, and it really doesn't, as we all know, It doesn't represent any sort of common law or whatever you want to call it. It's just a private court. We all know that, but we've got to bring that out, haven't we? We've got to bring it out.
Yeah, it was really interesting. You make that point because Helen put up a really good analogy earlier today of what would happen if you said, "Listen, I don't really understand. What would happen if I came in here with my own road traffic act? Okay, wouldn't you ask me for evidence that this road traffic act applies to, whoever I tried to apply it to?"
That's good. That's good, Helen, because you need to. Yeah, I think you do need to give them a ridiculous. If they say that's ridiculous, Helen, you should say, "I'm being honest with you. What you're saying sounds ridiculous to me," because they think that they thought I was playing a game, but after learning.
Well, the minute they try and go, I'm actually going to say so. I take being here very seriously. I'm here against my will today. You'd be here anyway, type thing.
Yeah.
I'm not playing a game. I'm asking you to prove that you have the right to have me here today.
Yeah.
Mm-hmm. Yeah.
Yeah, they think you're playing a game, and if it comes across in their attitude, you should say, like Mark, because excuse me, I'm not here. I want to get this resolved. You need to let me know what this acts of parliament are for. You've got to get straight into it.
Yeah, and you can even question whether they're playing a game. They're both representing the town. They're not asking for any evidence. What?
Yeah, I think that's a great, and keep that. If they get into abstract with you, and they probably will. They've done it 1,000 times to people. Say exactly what you just said. If I brought my own road traffic act in here, you would think that was crazy. This is what I think of what you're telling me. It's a brilliant one, Helen.
Yeah, well, they're telling me they don't believe I'm capable of knowing when I'm driving responsibly and when I'm not, and I have to obey their rules because I'm not capable. Well, anyone could go in and say that.
Yeah.
But then you've got to prove the active. Okay, fine, that's your decision. Is that you've made these rules? Where do they apply to me? Show me some evidence.
Yeah. How did you get the power? And
if the judge says they don't need to, then it's what's your relationship with the prosecution? What's going on here?
Yeah. Explain it to me like I'm a 10-year-old.
But allowing them to proceed without evidence.
Yeah. Well, you should say explain it to me like I'm an adult, not a 10-year-old, because that's what they are doing. But that. What you said there, if I bought my road traffic act, you would want proof. And the other thing is just to bear in mind that they think jurisdiction is given to them by God. So that's one thing you've got to
no matter what they think, they've already told you that you're presumed innocent of every element of the crime. It doesn't matter what they think.
Yeah.
There's a burden of proof on the prosecution as soon as they say yes to that question.
Yeah.
That's it, yeah. And I mean, in your case, Paul, when they actually told you that they were going to have hearsay witness come up and not the actual bloke who was accusing you, you've got to be more aggressive in terms of once you go into court and that's coming. It's a different story if you don't know what's coming when you first walk in there. But if you know that's what they're going to try and throw at you, you've got to object to that and let them know you're pissed with them over doing that.
Yeah, but it turns out, Vin, that even if the other guy would have come, he would have been a hearsay witness as well, because all he did was look at the same information that the new guy did. All these traffic fines, all these camera tickets are the same. They don't need any witnesses. So so there's no witnesses that any code applies because there are no witnesses.
The only thing they're relying on is the violation of a code. So they cannot say that evidence that the violation of the code is applicable is irrelevant. Well, they can say it, but it's good, let them say it and let them then clarify it with them. So you're telling me that you don't need to provide me with evidence that the act is applicable in order to charge me with a violation of it. Get them to clarify.
The clerk. So I'll tell you what happened. There's none of these codes were mentioned during the hearing. So what the clerk and the judge, they go behind the scenes for 10 minutes, and they come back, and that's the point where they discuss codes. I imagine that...
Did they actually leave the room with you, Paul?
They leave the room together, and then they go over their notes.
They didn't with me. They just sort of had their little private huddle in there, but they didn't leave the room. I could just about pick up some of what they were saying, and I was still objecting while they were having their private conversation.
The trial is the trial. They're the different play. They're playing a slightly different game. So all you get is the witness. They get the witness, you get the witness. Then they waddle off for 10 minutes, and they come back. So that's the part. I don't want you to even experience this, but I'm just telling you that. Because this is when they...
They'll be lucky to get that far.
Oh no, I don't want you to get... That won't happen tomorrow. Yours is just be a nice time to...
Well, just, to get that far, then we're going to have to have got through the plea part, aren't we? And the application to dismiss part before they can put a witness in front.
Oh yeah, you're weeks away with that. Don't worry. They won't spring that on you because they haven't given you the bullshit yet.
If they want, it's just more grounds to appeal. But I just think they're going to be sick to death of me well before we get to any witnesses.
No, yeah. What I'm saying is they hide these acts. They don't talk about them. And I think if I did it again, I'd have asked them more about.
It's on your sheet, Paul. It's on your sheet. That's what you're charged with violating. Well, mine is the Road Traffic Offenders Act. Is actually what it is. That's what I'm.
Yeah, I'm just saying that
you can raise it. You can say that's the charge I've been told I'm being accused of. Is that correct? Is that the only evidence of a crime? Because we know that's not enough, but also it's like, but if they are going to go ahead and assume it's enough, then they've at least got to prove that it's a valid act that applies to you. Otherwise, they look very stupid if you've asked and asked and asked.
They've got to know how it applies to you. They've got to know how, when, whys and wheres, how it applies as well. It's not just a matter of them...
It's not just a case of them knowing. They've got to also be able to show me the evidence. Otherwise, are they withholding evidence from me? Have they seen the evidence and they are not showing me?
Mm-hmm. So. Yeah, that's it. I mean, that's what we mean by first-hand personal knowledge. It's them having facts, knowing how the law actually applies. And we already know the answers to these questions. So
when they say absolutely, like jurisdiction, when they're telling you absolutely they have it, then at that point say, well, you're obviously in.
It's arbitrary. Yeah.
The evidence. That you have that power, and I haven't seen that evidence. So
exactly, yeah. That's when you challenge them and you state.
If that's so, it should be easily demonstrated that there's evidence.
What I'd say to them, is that an arbitrary opinion that you have jurisdiction? Yes or no? Is that an arbitrary opinion? They'll have to go. Well, no, of course not. Right, I say it's based on facts currently within your knowledge. Then, correct? Yes. Right. What are those facts?
Yeah. That's it. Sometimes they say it's self-evident, and sometimes you have to say right back, if it's self-evident, let the evidence present itself, Mr. Prosecutor.
Yeah. See, what's happening is the judge is filling in that last element of the.
So then you ask them what their relationship is with the prosecution, why they are offering evidence for their case. When they're supposed to be impartial.
I think that's the thing I couldn't get quite clear in my head. It's the judge and the clerk that are giving that evidence. So,
and if they are going to testify in evidence against you, then they have to recuse themselves. You can't sit and be impartial on a case in which you're testifying against one party.
I think every single time the judge seems to offer the prosecution a helping hand, you just need to call on, excuse me, what's the relationship here? Are you colluding with the prosecution to?
Yeah, and at one point the judge cross-examined the witness as well, which was just
really.
It only occurred to me as I was driving home, but because he hadn't mentioned something about the insurance. How many people were insured? And then the witness answered 2, but that would have been given me actually a loophole if I'd have wanted to go that way. I said, oh yeah, the witness hasn't failed to mention how many people were driving. It could have been any one of 100 people, if you wanted to do that. But yeah, the judge stepped in and asked that question. So it's outrageous, really.
Yeah.
I'd imagine she was a solicitor once. She couldn't help herself. But yeah, so good luck, Helen. I think it's going to be it's going to be a bit more relaxed than a proper trial anyway. So
it's going to be a case management hearing, isn't
not
it?
for them, hopefully.
Yeah, it's just a case management hearing. So they write it down on this big long 3-page form. So you can cooperate with that, but make sure they write down evidence that the code's applicable is, on the form at least.
Well, they're going to have half a dozen transcribers sat in the public gallery. So whatever they write down on their silly little form doesn't really matter.
Yeah, it might be in a meeting room. You never know. It might be just in a meeting room.
No, it's not. It's in the courtroom.
It's in a courtroom. Okay.
Yeah.
And ask.
Last time.
I know.
I'd rather be in the courtroom. I'd rather be in the courtroom because then I can have my own people there as well.
Yeah, there's a case management a form that they fill in. So if you don't see that, ask if you can see it. Say, is there some kind of document that you're filling in? I want to see what's written on it, because you're supposed to sign it. So just keep that in mind.
Yeah,
I'm not signing anything.
The other thing,
of course not.
The other thing you got to bear in mind, Paul, is that there's 41 different police forces in this country.
No, this is the
different ways in which the Crown Prosecution Service interacts with local judiciary at magistrate level or local district level, concessional district level of each county.
Right.
So each and every one of those interactions is going to be, relative to each area. For example, when Helen put in an application to dismiss, when asked that, would you want the case law, put in a complete document? Would you like, the case law listed? Would you like, any other information listed? And they said no, just the basics, and if they want any more, they can request it.
Right. Oh, yeah.
So, and of course, I know that's very different in other jurisdictions where they insist on case law, being attached to every application.
I was just it was a Crown Prosecution website. I was looking at the standard forms that they use it with solicitors mainly, but just so you know that they make sure you check if they do write any of their own notes. You have a look at them.
Yeah, well, I mean that's a big chunk of what we're doing. As I said, right from the very, very first instance of any being aware of any charge being put against you, you're asking for that evidence. You're asking for that evidence of jurisdiction. So any calls that you make to the CPS requesting evidence, they're much more likely to give you any evidence as soon as they can, because you're actually questioning undisclosed evidence. And of course, when you do get to any kind of hearing and you really are pushing the point, listen, you have no evidence of jurisdiction. Okay, you're not showing any grounds to even make me warrant a plea here. There's evidence that I've not got, more evidence that I've not got, that I've been requesting for a long time, or somebody's withholding something from me. So, when you're, where that's one of your strongest points of pressure, to understand exactly what type of hearing show trial it is, and you're pretty sure that anything else that they could throw at you to distract you in the way of paperwork, in the way of other things, they're definitely going to throw at you.
And don't be afraid to do something unusual and just say, do you think that you've got jurisdiction because the Queen told you? Like if they're being really obstructive and just keep repeating themselves, I would suggest that, turn it right up a notch, because it is ridiculous, isn't it?
I think it's very important for people to be aware that there's a lot of things that they can do to slow down and speed up. A lot of them like to go through as fast as they can because it gives them the opportunity to railroad you and distract you. So sometimes strategically making notes of things that they say. Because if they proceed while you're making notes, again, it doesn't help for their show trials.
And that's a good thing. And I remember hearing a podcast I think it was Roger Hayes, and he said he uses a little tip, and I just remembered he asked the judge their name, and Mr. Johnson, and he said, "Can you spell that out, please?" And he made the judge spell out his name, and I think just psychologically, it made the judge slow right down, because it's just one of those little things that you were saying, just to slow them down. Oh, can you just repeat that? Yeah,
and there are other techniques that are also quite useful. For example, when you're asking yes or no questions, it's often useful to read the question as you do from your notes and gain eye contact with who you're asking the yes or no from. And you'll find that they're much more likely to take it as inquisitive rather than confrontational. And they're much more likely to give you an answer, especially if your eye contact is gentle. As an inquiring, I'm just asked after a question here, so we can get resolution.
And as Mark was saying, drill down and say, "Excuse me, just clarification, please. Are you saying?" That's what Mark does all the time in tax cases, and you'll find this is more similar to a tax case. Mark,
they all work the same way. Right through from a tax case to a drugs case. Right the way through, they all work in the same way. The show is slightly different.
Yeah.
For a traffic case than it is obviously for a drugs case, especially if there's a very serious prison term attached to it, or there's a lot of money involved in assets that they're hoping to seize. So it's a very different show that's put on, but the same basic theory applies. The same basic
point. Can we just clarify what you've just said? Are you saying that you've got jurisdiction because of the code, and they'll babble on some stuff? No, can you just clarify? Is it only because of the code? So was that arbitrary? And that's the thing I wasn't very skilled at doing.
And this is where they run into problems. You'd run into problems if you're attempting to use this method. If I came into your house, stole your TV and your computer, and hit you over the head with a chair, at that point, you'd say, "Is that the only reason you're relying on jurisdiction?" And you'd be able to go, "No, I'm relying on jurisdiction because you came in and you took stuff that wasn't yours and you caused this man a very serious injury. And this man is standing to complain against you to be made whole again." That's where it won't work if you have a legitimate cause of complaint. But if you're trying to extort money from somebody because of some ethical law that you think applies to what they want to smoke in their pipe or what they want to smoke in their cigarette or how they drive their car, if they're not causing any loss, injury or harm...
accusatorial springs to mind, it's accusatorial.
Then if they're going to need some kind of substance to it. If they have a contract, then that's a different matter. If there's a contract that we have, and that causes me to come and repossess something that we had a contract for and you didn't pay me for, then that may be a different matter if that goes into a court. Because there's a contract there, and we can see if that's a valid contract and that we've both kept our side of the bargain, or if one person has defaulted on it, what the remedy is.
Well, that's it. That's something where you can give a timeline and everything else,
I was going to say, Vin, it's when they confuse that, where people have a genuine cause for complaint, with this kind of extortion, where it's just revenue raising from no real injury.
That's right,
injury that claim against society, which, is they have.
See, this is the thing. Sorry, go on.
No, go, Vin.
I was going to say, I mean, that's the thing with the whole issue over contracts. If this was a contractual obligation, you could take it from a timeline. You still couldn't prove that a statute would be applicable to you. You still couldn't. The facts still wouldn't be there, but you could at least prove that an obligation was created in the sense of you agreed to do this and you agreed to do that because we've got you. We've got you got a bit of paper where you've agreed to terms and conditions, you agreed to pay X amount of money in return for this, blah blah blah. And with a contract, you can put together a factual timeline, at least show there was an agreement now. The fact that you can bring force against somebody, then use violence to force them to fulfil that contract, you can't show facts proving that gives somebody justification to do that. But the thing with a contract is you can at least show a timeline, and you can put some substance behind it in that respect. Whereas when it comes to a malum and say, a malum prohibitum claim, the only way they can prove that, they can't prove, they can't point to where that alleged, obligation was created. I mean, say it's a statute that was created in 1700 and something. You telling me that the obligation started there? For me, that's when the injury at Damden began, and it started concurring from that point onwards. It's ridiculous. You can't. You can't prove that. You can't show that.
Yeah.
If somebody's got a contract in front of them, and they agree to this, and there's two parties coming together, and maybe a third party witnessing it, you've got something you can get your teeth into. And that's the kind of standard we're trying to hold them to. Now, this is where the Freeman thingy comes in, and they give it, oh, well, there you go, that proves it's all contracts. That's the only way the government can have, it's all consent of the governed and all that crap. Yeah, go on, improve it. Show the contract. Show the paper trail proving that.
Yeah, I'm pretty sympathetic to Freeman, because if they've ever been in one of those courts, they must walk out thinking, how the hell did they get our consent? It's confusing, for most people. But if you look at how a proper court case works, all those great case laws. This
is the thing. People criticise us and criticise Mark's method and everything. I've actually seen, and when I do my workshops, this gets people can get this information through my workshops regarding how a cause of action actually is meant to be laid out. I've got High Court paperwork where I've seen a case so far where the cause of action has actually been laid out. It doesn't mean there were any facts behind it still, but the manner in which it was all laid out, it was done correctly. All the elements that should have been there were present, and I've actually seen High Court paperwork with a proper laid out, or 99% a proper laid out cause of action. So I know what one of these things should look like. I know this isn't just piss and wind, and we're saying they should have this and have that. And then when you put this in front of a court, they're turning around saying, we've got no idea what you're talking about. We don't know what you mean by all these elements and this, that, and the other. Bullshit. I've seen it for myself. I've seen High Court paperwork with a cause of action laid out properly. Doesn't mean there are any facts behind it. There wasn't, but I've seen the way it's laid out, so I've at least seen how, or at least how a proper claim, when you bring the claim against somebody, and you should include all the elements, I've seen one of those laid out properly. So I've seen it with my own eyes, and people can get this information from me, when I do my workshops and that. So, we're not talking codswallop here in terms of, we know how this paperwork should look. We're not just blowing this out of our arse. We're not just reading this in book saying.
I think everyone knows there's something wrong, but they can't quite put their finger on it, and we need them to admit that there is no obligation to fill forms in. Exactly, there is no obligation, and we've got to do it with these clever questions, but we've just got to get ourselves out of this whole mindset that there is a contract with the government, because there's not. It's pretend.
Exactly, there never was. There could never have been.
No.
There can never have been, at any point. Isn't like, a lot of the Freeman situation and a lot of these so-called some of these self-made gurus and that, like to pretend as if it all started off as a good thing. Oh, it started off under a trust, and the Queen was there to protect the land and hold it in trust for us, and all this, that, and the other. And then, and then it got corrupt. They just got greedy and got corrupt. If you look back over the history of this country, and there's a chap called Jupp. Is it Jonathan Jupp? I can't remember now. Sorry, he was a High Court judge. He wrote a book called Stealing Our Land, and was a former Supreme Court judge, as far as I remember. And he wrote a book on this, and he goes into a lot of the history behind all this. And the truth of the matter is, this isn't a matter of, it started off as a good thing and then got corrupt. There's always been people all over this country, since Saxons and everyone else started coming in, people claiming land and claiming they own it, and then having people working under them as slaves, pretty much, extorting them. And this has always gone on. You know, it isn't as though it started off. The Constitution was a good thing to give us a king, and the king was there to protect us and going to represent us and all this stuff. Bullshit. The history of this country has always worked exactly the same way. The only thing that's changed is the technology that's come along. You know, that's the only thing that's changed. But the mindset and the way that we've always been controlled, and how people in this country and its resources have been controlled, been done exactly the same way for thousands of years. Nothing changed in that respect.
Assumptions. It's done on assumption and deception.
Exactly.
It's like me going round a nice old lady around the corner and collecting the
useful to maintain control over the resources. And they view us as a resource.
Yeah, I think they do.
There were some papers written back in the early 1900s. What was it called? The Great. What was it called? The Great. I can't think of the bleeding name of it now. I had it on the tip of my tongue then, but it was basically a group of papers, or quite a famous book that was written by a chap, and basically he stated that yes, people are to be regarded as natural resources. Same as
Kissinger talked about the soldiers, didn't he? About them being useless. I forget the phrase he used about his American soldiers, pawns. I think he said when he sent them millions to Vietnam. He actually wrote in a book. He referred to them as pawns in a game.
They're cannon fodder if you're in the army. You're just cannon fodder, especially if you're in the infantry or something. You know, one of those regiments. But it's this is the way it's always been. And the way the Freeman and the Dean Clifford stuff. You know, when I talk about this all being a trust issue. It's codswallop. What was it ever founded on? Where's the paper trail? Where's the proof that it's even a valid trust? It could have been founded on anything valid. The people who took over this land, the people who gained this level of control over us, the elite families, as you want to call them, these nutcase families, they're, they gained it through corruption. They never gained it through people's consent, and it started off as a good thing and then got corrupt. It was built on corruption. The entire constitution, the monarchy, the government of this country was built from a rotten barrel of apples. It was already corrupt. That's why corrupt people are always going to try and gain control over other people. I mean, fair enough, the church has got a lot to speak for this as well. Organised religion. That's probably the bottom of the shit pile in terms of.
I think when you do start to follow it back, as you probably did, you go back to the Constitution and you study history, and it doesn't make sense. And then, like you did, Vin, you go and look at how the higher courts work, and you put the two and two together, and you realise they're treating us like kids. And what you believed by going in these Mickey Mouse courts. It's not surprising you'd come to some ridiculous. There must be a trust fund. Then I can completely understand why they come to these theories, because we've been so messed with it. We've been so brainwashed all our lives. We've come up with another theory, but it's just as daft as theirs, really.
Exactly, yeah. And this is the thing with a lot of these people. They want the world to fit that reality now. They've come up with, we've worked it out now, it's all trust or everything else, and now they want the world to fit that opinion. It doesn't happen that way. You've got to let your opinion conform to reality. You can't let reality conform to your opinion. And this is what a lot of people talk about in some of these groups. You can make the world whatever you want it to be. No, you bloody can't. The world is what it is. And you got to deal with it as it's thrown at you. You can't make, in terms of your own life, you can make decisions and have a certain level of control over your own life. But events that happen around you, not really. And the fact is that you're not really free. Think of something you can do in this country or any other country in the world. And I'll put that in brackets, countries. There's no such thing. But put it in the context of think about something you can do. Try and count on one hand anything you can do with your life, where you're free to do it with no government interference in any way, shape, or form. Now try and think of something. And I've had out of people giving it, saying to me, I can get in my car and drive the other end of the country if I wanted to. Yeah, really? Don't you need insurance for that? Don't you need a driving license for that? Don't you need to, pay tax to do it? Don't you need to pay, if you're going to put fuel in the car, you've got to pay tax to the government. Now show me the government never interfered in your alleged, ability to go and do that.
Yeah, so
things. Just trying to think of something you can actually do with your life. At what
level, like, if we can admit that we've probably been deluded, we've made a lot of assumptions. At what level, or what people in the community actually think? Obviously the Prime Minister knows at some point that oh dear, it doesn't quite work like I thought it did. The royal family must think it's hilarious. Do you think there's a few thousand people scattered around the community that just think this whole world is bonkers and know why?
I think that's generally older people, you find. And they just stop caring. They get older. Yeah. They see the world's a madhouse and it's like, oh, let them get on. I know the world's a madhouse, let them get on with it.
Yeah,
so a lot of people are like that, but it's... the thing with this is with the truth movement, if you like, this whole community that's building up out of people, waking up to this stuff. It's all ages. It's not one particular age group that's actually wising up to this. But what you generally find is that the older population is you get two sorts of people. You get the type of people who give it none of this surprises me at all. And they'll just get on with their life and say, well, it doesn't matter there anyway. It's not a lot I can do about it. I'm too old, too worn out. I've paid I'm either screwed on a pension or I've paid my mortgage off and I'm happy, sort of thing. And they just let it go. And they just put up with the fact, and they just sit back, rest assured that yes, the world's a madhouse and there's nothing I can do about it, sort of thing. But then you get other people, obviously, who want to fight back and do something about it. There's something not right about this.
Mm. But everyone agrees. Everyone agrees. For example, Adolf Hitler was a bit of a crazy man. But do you think he actually thought he was actually doing the right thing, or do you believe that he thought
himself he was? Absolutely, yeah.
He must have thought he was a god. It's like a god complex, isn't it?
In that sense, yeah. But it's people only look at that man. It was the people who were behind him.
Yeah.
The people who put him in that position and capable of doing what he did. They're the people who are the really evil ones. They're the people who we should be pointing to or looking for.
Well, they were tricked, though, weren't they?
I think in terms of looking at people, it's the people who want to control. That's the underlying theme right the way across the board, from people who can think they're doing good things. Often some of the magistrates that we come up against, I'm sure, genuinely think they're acting in the best interests of the community, and some of them can't actually understand what we're doing until they really look into it and sometimes walk through it, right up to people like Adolf Hitler who do unspeakable things, and he must have thought, well, it might be tough, but I'm here to do it, or whatever was going on in the crazy guy's mind. The underlying thing, they all want to take control of other people's lives. And that's the main thing. As soon as we can get around to getting a system that encourages us to take 100% control of our own life 100% of the time, and no control over anybody else's life, except without their consent.
Well, exactly. Yeah, that's right. I mean, sometimes we end up with people who we've got to. Forcibly take control of them. If they're either a threat to themselves or to somebody else. You find some people who end up mentally ill. They're incapable of knowing what's best for them, and sometimes you do have to use force to help them. Even though what you're doing is actually using force. You're creating an involuntary relationship. Sometimes it can be justified on certain grounds, but there's very few points where you can actually justify initiating violence.
Yeah. I mean, and
really, it's self-defense. Period. That's really it. And none of this can be justified. None of these statutes or the way the government operates, none of it can be justified on any of that. But they use that as an excuse to say, "Oh yes, we're doing this to protect you." Well, as Mark was talking to that solicitor last night. JT jumped in there with the Cheney case, stating that there's no duty to protect. You know, and that solicitor was saying, well, you know, we've got to violate people's rights in order to protect their rights.
Yeah,
well,
and
yeah,
you know,
that's totally contradictory. He admitted that to a certain point. Well, then you've got to get that straight in your head. What you mean by that? You know, it's initiating violence. Can you justify initiating violence?
Yeah.
Only in self-defense.
On other people to, you know, initiating force on other people to protect them from other people initiating.
Well, as he said it, yeah, to protect them from themselves. Who the bloody hell do you people think you are to say that you've got a right to protect us from ourselves?
But especially when it doesn't come through. You know, there's a case a year or so ago of a woman and daughter who had a court order restraining her ex-partner and I think the father of the daughter to visit the house, and there was no police response, and the long and short of it was that they were under no duty to her, even though she had a court order. So, you know, again, it just shows that even in this country, you know, even if people wind up dead, the police still don't have a duty to protect you, me, or anyone. Just some kind of fictitious generalisation. And that's nothing of substance, nothing that anybody can put up in court.
That's right, yeah. I mean, the most famous one in this country is the Jack the Ripper case. Smith versus Chief Constable of West Yorkshire Police, 1988. That's one of the most famous cases regarding this in this country, because the woman was being stalked by the Yorkshire Ripper. She went to the police and said, "We know she's a target of his." She went to the police, asked for some help. Police didn't want to know, said, "We can't do anything until something happens," as such. The poor girl did end up getting murdered by him. The mother took the police to court, and they stated, even when we know you're in danger, there's no duty for us to step in there and help you. Even when we know, you know, you could possibly, you know, something can happen to you. So one minute they're claiming they're there to prevent crime, the next minute they're saying, well, you've got an opportunity now to prevent something, but then you turn around saying there's no duty to step in there and you know. There's no duty on you to actually do that. So they contradict themselves all the time.
So not only is it a contract that they can't prove that you're a party to, it's not even a valid contract with, you know, a valid, you know, exchange of worth and a meeting of the minds. Yeah,
I mean, in a couple of those cases that I've read out before, it states that without a special relationship, the government, the police have no duty of care. So either as a member of the public as a whole, either to the public as a whole, or to an individual. And so, you know, what that means is, by there's no special relationship, that means that there's no principal-agent relationship.
Yeah, I'm sure, unfortunately, that some of this applies to children within the state's care as well.
That's true, yeah.
You know, I'm sure that although they have an alleged duty to protect the children as a mass, or as an entity, as some kind of fiction, but actually, you know, they have no real duty to protect anybody in their care on an individual basis.
No, that's right. I mean, well, the only time they claim when they've actually got a duty of care over you is when you're in their custody. So yeah, if you're dragged into a police station and all that, then now they have a duty of care to look after. Yeah. But we've all seen how they behave like that. I mean, like that poor woman who got beat up by that copper a couple of years ago in a I think it was a Met Police nick, wasn't it, in London, or it could have been up north somewhere. But you know, she ended up getting 10 bells knocked out of her, but it was all captured on camera, wasn't it?
Mm-hmm.
You know, Copper ended up getting, you know, losing his job, rightly so, but I think he got off with a pretty light sentence, didn't he? I think it was just a fine, and you know.
Unfortunately, there's a guy I think in Hampshire, and maybe Surrey, maybe Berkshire. I'll have to check, see if I can get back to you. But again, similar sort of thing. He was caught on camera throwing girl to the ground. She smashed her face up, got very bloody. She was in need of some kind of help, not really throwing around. And unfortunately, I think he's back serving as a police officer now. 3 years after that.
I mean, Ian Tomlinson case as well. Another, you know. Another case we can look at, you know, it's this the whole thing about you know, this whole duty to protect us and all that, or you know, what people want to believe is the government's there for some, you know, to do us good. to serve us. It's all complete codswallop. In the case law in this country, they're a little bit more careful about what they say, whereas in America, they're blatant about it. The state has got absolutely no duty to provide anything. We've got one famous case, I think it's the Bowers case. The state has got no duty to provide any services, even as elementary as law and order. We don't have to provide anything to you. That's what they were saying.
That's basically right, isn't it?
Don't even have to lay the buses on.
I can't believe they sit there on Newsnight and the people in the audience say, "Why do we let these guys come over from Romania and take all our healthcare?" And I'm silently screaming, "It's not your healthcare. It's just to fool you into thinking that's why they're giving it away, because it's just free anyway."
That's right, yeah.
And they go, "No, it's not free. It's we've paid for that with our tax." And I'm thinking, "No, you haven't." That's just a filing off the end of off the nail of what they actually take from you. It's probably 1% of the tax revenue. The rest of it is just they're just playing with just to control you.
That's right, absolutely. Yeah, and I mean, it's just bits of paper at the end of the day. You're not really paying with anything of any substance.
That's what it comes down to. Yeah, that's right.
So it's. People are waking up to this, thank God. It's getting out there, and I think a lot of it's down to their arrogance as well. We're seeing it in the courts, we're seeing it the way they're acting on TV with the government and these, ministers and everything else. People are waking up to it because they're not even trying to make this look good anymore.
I think it's our ignorance, including mine over the years, and my assumptions. But I think probably a great deal of the politicians believe it as well. They're like judges. They actually think that they're helping the public. I haven't really drawn a conclusion.
I honestly don't believe that's what goes through their head by the time they end up spending their time a solicitor. Because I mean, they've got to go through at least 7 years of being a solicitor or a barrister first before becoming a judge. So they're in and out every day. They're in and out of courts dealing with people like us, and it's not so much people like us who are challenging the way we are, but they're seeing the best and worst of society, and they start to paint us all with the same brush. They start to paint us all with scum, because they're always in cases where it's and they probably hear the most horrendous things as well in court. Most horrendous stories going in court. What people do to each other and stuff. And after a while, I think they just start to paint us with the same sort of brush. The same way that the police paint us, it starts to become a them and us attitude. And I don't think they honestly believe they're doing us any good. The way I think they start to look at us is where to be kept in line, where to be kept under control. I don't believe it's an issue. It becomes an issue of they're there because they want to serve us and do some good.
Yeah, and I also find it
becomes an attitude of where to be controlled. Where to be controlled because they've seen the worst of it.
Yeah, I find it staggering how now they use G4S security. G4S security are doing some of the police work. G4S have also got a legal branch, so they supply the judges now, and of course they run the prisons. So when people find that out, they're outraged. They're taking our traditional police and they're replacing them with corporate police. It's all the same. It's all the same. It doesn't make any difference. Anyway. It's only on the pay slip, isn't it?
That's right.
Whether the judge is being paid by the Crown or G4S, it doesn't make any difference.
And the money's still coming out. The alleged, forcibly taken from people as tax money. Yeah.
So we can't even get any redress if G4S did patrol my road for any reason, and then they decided to sneak off for a couple of hours, and somebody got robbed. There's no redress. If I paid G4S directly and that happened, they would be in deep trouble, wouldn't they?
Well, that's right, yeah. If you actually paid them to do that job, if there was some proper contractual agreement there, but there you go. But the attitude of the police is, well, we can't protect individuals because we have to protect the public as a whole. Well, then I've got case law where they state, well, actually, there's no duty to protect the public as a whole either. So,
yeah,
there you go. And then look at the American case law. They're absolutely blatant about it. In this country, like I say, unless it's more well hidden, they're a little bit more careful about what they say. But they're still basically saying the same thing. We don't know you people a damn thing. We're not here to protect you. We're here to control you. We're here to keep you people in line. We've got, those ants outnumber us 100 to 1. If ever they figure that out, there goes our way of life. That's what it all comes down to. This. And it's blatant. I've got to stick that. I've got to stick that on the show soon. That's going to be an intro, I think.
Yeah, that's a great cartoon, isn't it?
Because that says it.
Watch that again.
Yeah.
Yeah, I think it's very, very true, and I think the more people that actually see, the man behind the curtain, as it were, because that's what it is. When you go in there and you have some really simple questions to ask them, 1, 2, 3, 4, 5, 6 questions down the line, and they're not playing straight, and everybody can see that, then you start to see the man behind the curtain there. Because,
that's right, yeah.
If it is something serious, they'll say, yep, I'm sorry, you did this to this person, or at least that's the accusation, and here's this person to prove it. Here's the person who you caused loss to. And when they don't do that, and they come up with nothing, but bullying you, and that's what it is. Unfortunately, it's very well spoken, but it's incredibly intimidating. They're sitting 3 feet off the ground higher than you. That's intimidating to start with. Yeah, and that's it. But once people see that, then more people realise that actually it's just a few of them who are saying get in line, and it's just the illusion that they're doing it. And when you hold their feet to the fire by just asking questions, then they expose themselves.
Yeah, that's it. I mean, it's a thing of the Nuremberg trials. Look what happened during the Nuremberg trials in the end. After everything they got away with, they thought they were right, and what they were doing, they had absolute right to do it, and then they ended up in front of a court called, in front of them. And that's when it hits home about what you really did. What you was really involved in. I suppose the people who were really the people who were pulled into those trials, and what it showed the world. Sometimes we get it right in terms of we brought those people to be held accountable for what they did during the war. Even though the people who actually orchestrated all that was just another dog and pony show, just to convince the world, look, we can act reasonable and we can act fairly and all that. We can't allow people to behave this way and all that. And yet the people who actually orchestrated the Nuremberg trials are the same people who orchestrated the war in the first place.
Yeah, and also the same.
It's a contradiction in terms, but it just goes to show.
Nuremberg was a better job than Versailles in making the dog and pony show look effective. But it shows its true colours when the same people that were organising the Nuremberg trials were making sure and assisting other war criminals in starting a new life in Operation Paperclip in privileged research positions around the world. And that's all on public record. You have people, I think it's in Singapore, where they have war crimes tribunals that have already found Blair and Bush guilty of Nuremberg crimes, and so I think they're not even allowed to travel to Singapore without the threat of being arrested, and so that's one area. But it's the same thing with The Hague. They're supposed to convict war criminals there, but it only seems that they convict war criminals who America, Britain, and the other UN Security Council members don't like.
That's true. Yeah. If they cheese them off, or rub them up the wrong way, then
it's a good dog and pony show. But again, unfortunately, it's just a dog and pony show, Vin.
Mm-hmm. Yeah, and that's the way people have to look at it. In terms of understanding that the people who are really behind this, the people who create all this chaos, and in the next minute claim they can actually put it right and end it. Are the same people. You have to realise your enemy. I mean, as I was going to mention earlier about the judges. What does a judge wear on his head? As we were talking about this the other day, a dead sheep. We've all heard of the wolf dressed up in sheep's clothing, haven't we?
Maybe it's to do with giving you a fleecing.
We've just had a 3-minute warning, 3-minute reminder. Then you've got 3 minutes left.
Sure, yep, well, okay. Well, we'll bring the show to an end now. And thanks ever so much, everybody who's taken part. Thanks, Ellen, Fabrice, and Paul. It's been a great show. Thanks for joining me again and helping me keep it going. I'll run out of things to say, no doubt. There you go. That's all right. And I'm going to be coming down to see you soon because I'm going to be there with you tomorrow at your hearing, Helen, tomorrow. So I'm looking forward to this.
Yeah, looking forward to seeing you.
Yeah, and I'll say I'll be getting things organised now after the show. So what I'm going to do is we'll cut the show a couple of minutes short, I suppose, and we'll stick a bit of music on. So thanks again, everybody, for listening in. This is the No State Project UK. That's all right, Paul. Thanks again. Yeah, thanks, Ellen. Thanks, Fabrice. And so this is the No State Project UK chapter, and we'll see you again next week on Sunday. And Mark's show again will be on Saturday night. It's now at the earlier time of 8 o'clock. There's been a change in the time zone thingy, I believe. Maybe it's summer months hours or whatever kicking in over in America already. So anyway, so it's starting an hour earlier as far as I'm aware at the moment. So in this country, so now it's 8 p.m. GMT time. And you can listen again on the Sunday to the commercial-free version, reloaded, on Darkcity Radio. So, if government was there to protect your life, liberty and property, as you already know, it wouldn't be the first to take it away. So, that's me signing out for now. I'm Ben James, and we'll see you again next week. Thanks for listening in, and ahoy and for now.